I'm informed by my advocate that Migdalia Salazar was here for the 7.
Oh,
And then when she saw that my advocate and investigator were here.
No, no,
she
no, no.
left.
tell the attorney to come in on
Well, he left too.
tell him he needs to be, Norma, call the attorney, tell him he needs to be here.
I do not. I do.
Tell him, because otherwise this hearing is going to take place and it's going to take place without his presence. And we will put on the record that he was here and the court will sign this not pro tunc, which means that the motion to dismiss will be rescinded. So if he wants to have a say in that, he needs to be here and his client needs to be here.
Right here.
Okay. All right, thank you. Just let the jurors know to remain outside. All right, counsel, it's the court's, we're going to go on the record. The court is calling 2021 CR 9849, State of Texas versus Migdalia Salazar. Can I have parties announced for the record for the state?
Travis Banks of the state of Texas.
Defense?
Charles Peters.
All right, Mr. Peters, where is your client? My understanding she was in court and she left.
I'm not sure, Judge. My office is attempting to contact her.
All right, my understanding is she was in court and she left the building.
I have no idea, Judge. I have just messaged for my client for the office to try to contact her.
All right, for the record, the court is going to note that your client was present and your client left. So the court is going to hear this order for judgment on nunc pro tunc. Have you had a chance to review the state's motion for the
I have.
judgment? Sorry?
I have.
All right, are parties ready to proceed? All right, court is going to grant the state's motion. All right, let your client know that their case is going to be reopened. Is there anything else from either side?
Nothing further from the state. Cool.
All right, and if your client needs to appear, counsel.
So when you say the case is going to be reopened, on what grounds?
The state filed a motion to dismiss. According to their motion, they filed the motion in error. What they did was they filed a motion to dismiss based on the fact that the defendant was convicted or granted deferred adjudication in another case. My understanding is your client was not convicted or granted deferred adjudication in another case. And so that it was incorrect. And I have notated on the motion for dismiss after the court signed it, it says state and defense state reason for dismissal incorrect. Both requests dismissal withdrawn. So on that date, both you and the state asked that dismissal be withdrawn and another dismissal be filed. And the court is not in receipt of another dismissal, and the court is not signing another dismissal until your client makes an appearance. Now, with regards to the nunc pro tunc, the court has signed it because the dismissal was entered in error. So the court assumes or presumes that the state is going to reopen the case. And for the record, the court is again noting that your client was here and your client left the court.
And on that matter, I do need to address an issue on the record.
Yes.
It's my understanding that the state has applied for a subpoena in the companion case against Fidel Ayala. It's my understanding that there was an intention to serve Ms. Salazar today at court with that.
Well, if everybody would read the case law and realize that when someone is supposed to appear in court, I don't know if your client knew it or not, but once they appear in court, if they're here for a court hearing, technically they cannot be served a subpoena in court. But obviously, either your client was given bad information or your client decided to leave because somebody informed them that the state was attempting to serve them with a subpoena. When a person is ordered to appear in court, according to case law and the rules, They cannot be served at court when they have an order to appear in court.
I understand that. I
So,
also
who-
needed to address.
Who informed her to leave the courtroom when the court ordered her to be here?
I didn't tell her to leave, Judge.
Oh.
So I don't know why she left. So, and we're attempting to contact her. One of the questions that I wanted to address is that the original dismissal was actually signed and entered. I received the rejection notice of the case so that it is dismissed, which I believe ends the court's ability to order her to appear.
Here's the thing, what I need you to understand. What I want you to understand, if both the state and the defense on that date knew that that order was incorrect, that the state had filed the motion for dismissal incorrectly and said that she pled in another case, both the state and the defense told me, Judge, that's incorrect. She did not plea in another case. And then what ends up happening is another motion to dismiss is submitted to the court. And what I wanted to know from the both parties, because my mind is a steel trap, I wanted to know why the case was being dismissed. The state said it's because we cannot get in touch with the complainant. And I asked the state, who is the complainant? They informed me it was a child. I said, how can you not get in contact with a child? And I said that I wanted the caseworker here because both the state and the defense informed the court that the CPS caseworker had closed the case. And I said, well, I would like to hear that from the CPS caseworker. And both parties like, no, that's what the CPS caseworker said. And I said to both parties, do you want your bar card on the line for that? And then both of you all backed off and said, we will get the CPS worker here either by Zoom or in person.
I would actually like to correct that, Judge. I believe at the time that I stated that I was willing to proceed without CPS caseworker.
No,
present.
you both said that you would not put your bar card on the line just by saying that, and that the CPS caseworker would
I
be
do
here.
also would like to address that I believe that there was a second dismissal that was submitted with that different.
Which I did not sign.
Is it still part of the court's file?
No, because I did not sign it.
So it was discarded?
I did not sign a dismissal. And what everybody needs to understand is that the court can sign a dismissal or not sign one. I chose not to sign it. And if that dismissal were placed in the court's file, it would not be valid because the invalid dismissal that I just did a knock on would be the law of the land. So thank you. Court is
I have
calling.
one final issue to
Yes.
address on the record. It's my understanding that there was an ex parte communication between Brittany Mitchell on behalf of the state of Texas
To who?
and the court.
No.
Your Honor, he's just referring to discussing the scheduling of this hearing yesterday when y'all discussed that we have this hearing.
No, I told the court coordinator to put this on the docket for today. And this case was supposed to be on the docket before then, because when you both were here, I gave you a date for you all to appear. So the court does not do ex parte communications. Thank you. Court is calling 2023 CR 3276